Well, it's 12 o'clock and we want to welcome you to Bench Bar Conversation featuring the United States District Court, Southern District of Ohio. We're here to talk about changes our courts are making to adapt to COVID. And the court is very grateful to the CBA and particularly Lisa McPherson, its executive director, Kate Lawrence, the CLE director, and the president, Joe Hyde, for setting this up. And here we go. I'm Tim Black, and I'm joined by my colleagues, Judge Douglas Cole, Judge Michael Barrett.
Morning, guys.
Magistrate Judges Bowman and Litkovitz.
Hello.
So we have turned out the team. And in terms of as we proceed, if you have questions, we've received a number in advance, but if you have questions, you can go to the Q&A box down at the bottom of your screen, click it and type in questions, and we will try and see them and respond to them. But in terms of where is the U.S. District Court today in light of COVID, the U.S. District Court is open and working. Physical entrance to the courthouse is prohibited through the end of May unless amended, but the court continues to work remotely, virtually, by video, and no less by phone, and we are proceeding. Nonetheless, in general, there are no juries, there are no in-court physical presence hearings, but we continue to work and try and be responsive. In the area of criminal law, it's challenging because of the Speedy Trial Act. In the context of civil law, as stuff gets delayed, justice is delayed, but we're doing the best we can, as are you, and we're pleased and proud. The truth is that the magistrate judges are on the front line because they're having to deal with regular appearances for criminal cases, initial appearances, and the like. But we're all working. So I suspect many of you are civil practitioners, but very quickly might be eye-opening to hear how the magistrate judges are keeping the court active on the criminal docket. Judge Barrett and I are elderly and we're being very careful to protect ourselves. He has particular preconditions, but be that as it may, life goes on, the court is open. Judge Bowman, I think you were criminal duty judge last month, and I think Judge Litkovitz is this month. Briefly, Judge Bowman, kick us off. What's going on in terms of progressing in criminal cases?
So I will just talk briefly about signing warrants. So for many years, I've been moving towards signing warrants electronically, just to make it easier on nights and weekends when the agents needed warrants signed, and that has proven to be really helpful during this time. So since March 13th, I think, the school closed, I moved to signing all my warrants remotely. So I have been doing them electronically for quite some time, but now it was all remote. The agents would call in via FaceTime and we would sign the warrants that way. The criminal proceedings at that time were still happening in person with some safeguards that were taking place. We've now changed that procedure a little bit. So I'll let Judge Litkovitz talk about that because I haven't done it yet. And she started doing the new procedures in April. So Judge Litkovitz, do you want to talk about that, please?
Yes, thank you. So beginning of April, we moved toward virtual hearings, and you are looking at my courtroom right now. I'm in my dining room, but due to our terrific IT department, the lawyers, the judge, the U.S. Marshal, the defendants, pretrial services, all the participants are participating remotely through GoToMeeting. And we had a couple of hiccups along the way, but now things are going smoothly. We are able to socially distance from each other to make it safe for all of the participants. And, you know, any lawyers out there who have got a criminal practice, if you will be appearing before me or Judge Bowman, you know, feel free to contact our offices to get the information on how you can appear remotely.
Well, thank
Can I
you
jump
both.
in?
Yes,
Can I
Judge
jump-
Barrett.
Can I jump in, Tim?
Yes.
Yeah, and I don't know how the rest of the rooms are working, but our courtroom deputies are trying to see what criminal matters are time sensitive. There are certain things where it just makes sense to move things along. And we have set up some pleas by video conference and also some sentencings by video conference. But in those situations, it's incumbent upon defense counsel to obtain written waivers prior to the hearing that they're willing to proceed by video conference. So we do plan on, you know, doing as much business as we can, especially on the criminal docket as we move through this whole pandemic process.
Very well. We're going to move to audience questions momentarily, but Judge Cole, do you want to be heard as an opening statement in general? Are you surviving? What do you make of this?
Yeah, so I've already done change of plea hearing by video conference. Thought it went very well. You know, we are trying to use this time in our chambers to look at any dispositive motions that have been pending a while and try to get those moved forward. And obviously we've been doing a lot by telephone too in the civil cases, and you can get an awful lot accomplished that way, but we are trying to stay productive in terms of keeping the cases moving while we're waiting to see how this pans out. Hopefully, you know, we'll be open for business a little more fully in the not too distant future.
That's interesting. You're using this quieter time to work on pending dispositive motions that may have been pending for a while?
Yes.
Those are the cases that were transferred by you, Tim.
I wasn't saying anything about anybody.
I was just going to say I don't have any of that. So in any case, moving to general civil practice, how are each of you treating requests to make changes to scheduling orders in light of COVID, where no trial date has been set? What do you make of a general request for continuances in civil cases? One of the district judges want to launch?
Sure, I'll start. So if somebody has a request for a continuance, what we've been doing is we've been trying to set up phone conferences just to find out, I mean, is there really a need? What's the actual situation? But obviously, if we haven't set a trial date yet, there's really not a large negative in pushing back some dates. So we're trying to be responsive to that. And basically, you know, it's like any other, I think most of you guys that are listening out there know that I'm really flexible on trial calendars and internal deadlines and things like that. So for us, it's the same operating procedure. If you've got a reason to move a deadline, we set up a conference call, we talk about it. And because this is just an added factor in that whole process. So, you know, I try to remain, as I always have tried to be, flexible in terms of accommodating the schedules.
What's your sense, Mr. Judge Cole?
Yeah, we've been very amenable if the parties are in agreement and the requested extension is not too long. But, I understand the court's taken some pretty significant steps to deal with the pandemic. So I'm not altogether surprised when parties say that they are likewise struggling to meet some of the discovery obligations or things along those lines. And as long as both parties agree to some kind of extension, we're pretty amenable to that.
Can I jump in on that as well, Tim?
Yes.
Yeah, I mean, as a practical matter, guys, when you're out there, if it's one of those cases where all along the way, one side has been requesting continuances for whatever the reason might be, and the other side is not happy with it, and we've extended, then all of a sudden we get the COVID request. Frankly, I'm a little more skeptical than I would have been if everything else in the calendar was moving as everybody had anticipated at the case management conference. So again, it's, kind of understanding what each case is like and trying to figure out, what the best solution is.
So if a civil lawyer has a discovery deadline coming up and they communicate to the court, hey, we're really having trouble getting anything done. We got 9 more depositions to do. Will you kick the discovery deadline for 3 months? What do you suppose the response is across the board? What do you suppose I say, Judge Barrett?
I have no idea what you might say to anybody on any given occasion. But, if it is one of those situations where the lawyers have been working on the case and things have been moving along and occasionally they've had to, get some time relief, fine. But if it's one of those situations where every step of the way, Judge Cole made an interesting comment. He said, if it's agreed upon, no problem. And I tend to go along with that. But if it's one of those deals where one side has been basically dragging their feet throughout the process, well, then I'm going to take a look at it a little more closely and really want to find out what is the problem, because lawyers have been doing videos by Zoom. I've gotten a mixed bag of feedback on that. Some lawyers are saying it's working okay. Other lawyers are saying that they just don't like it. It's hard having a witness review a document. It's hard going through, some of the mechanical steps we've all done in private practice. You guys know what a deposition's like. Sometimes it's easy to hand the witness a document. If they're in a remote location, it gets a little bit different. And a lot of it depends on where the court reporter is. If the court reporter is seated with the witness, that makes it easier. If the court reporter is not, that makes it tougher. So you have to look at all of those things. But I've gotten mixed feedback. Some lawyers have been able to conduct discovery depots by Zoom, and they've said it's worked great. Other lawyers have said it's problematic. So it's really case by case.
Indeed, but spirit of full disclosure, I typically have not met a request for continuance that I don't find well taken. Judge Cole, what do you make of remote depositions? You're going to press people to get on with their remote depositions?
Well, as consistent with what I just said before, my preference obviously is if the parties can work something out that they're both amenable to with regard to video depositions. In light of the fact that the extensions we're talking about right now probably aren't going to extend beyond the end of May, or at least fingers crossed, that's what I'm hoping. It seems to me that I'm not to the point yet where I would want to order parties to go forward with video deps if somebody thinks they'll be prejudiced by doing a video dep. If this becomes a rolling 12-month blackout where you can't do discovery for 12 months, I may revisit that, but I don't have any reason to believe right now that's the case. So given the timeframes we're dealing with, unless the parties agreed, I don't think I'd be inclined to force them to go forward with a video dep.
Very well. If there is a civil litigation that runs into a discovery dispute and the case is referred by the district judge to the magistrate judges, how do you deal with discovery disputes? Judge Litkovitz, can you kick us off, and then we'll hear from Judge Bowman?
Yes, and well, during this time, it's really kind of business as usual with discovery disputes. I know both Judge Bowman and I have a standing order where before parties can file any discovery motions, they're required to call our offices for an informal discovery telephone conference, submit a 1 or 2 page statement about what the issues are, and then we talk about it. And oftentimes we're able to work with the parties and come up with a solution to the discovery issue much more quickly and cost effectively. So in the time of COVID, it's still the same as it was prior to COVID.
And is that your sense, Judge Bowman? I'm going to ask about another procedure momentarily, but just generally on discovery disputes, it's the way it had always been. Judge Barrett, please don't touch your face. Judge Bowman?
Yes, I agree with Judge Litkovitz. It is. I've had several discovery disputes, phone conferences in the last few weeks, just, as I would. I have, like Judge Cole and Judge Barrett, have received some motions seeking to extend some deadlines due to COVID, and I look at those on a case-by-case basis as well. But as my volunteer role as being the guardian of the Q&A, we did receive a question. Judge Black, do you want to go to that now, or do you want to wait until we move along further in the webinar?
Let's move to it momentarily.
Right.
I'm eager to ask all persons, but I know one person has done it. What do you make about civil settlement conferences? Can you do them remotely? Judge Litkovitz, you did one, is that right?
I did. And so we did it through the court's GoToMeeting system. And, I think there are pros and cons to doing the settlements by video. I think one of the pros is you keep the case moving along. And in my case, the parties were motivated to proceed. They had some preliminary settlement discussions. So the case wasn't delayed. You do have to have the litigants have this capability of video conferencing, and the plaintiff obtained the GoToMeeting and was able to do that. So for me to be able to look at the lawyers and the litigants and talk with them, and kind of establish a rapport, I think is really helpful to facilitate those settlement discussions. On the other hand, GoToMeeting was limited in that you can't put people into a waiting room like you can with Zoom and some other technology. So I would have to drop off the call to give the parties a chance to speak with their client and get back on the call. So it was a little cumbersome that way, but at least in my view, I like it better than doing it solely by telephone. But we were successful. We got the matter settled, and I think it was a good use of technology.
That's fascinating, and I was waiting for the bottom line. You did it, and you got it settled.
Yes.
What do you make of settlement conferences? I'll ask you momentarily, Judge Barrett, but Judge Cole, are you eager to do a settlement conference virtually?
I would hesitate to characterize it as eager. That would be one where I would hope that we might be able to agree to put that off. I think settlement conferences tend to be far more effective in person, and unless there's some compelling need to do it right now, I think I would be inclined to wait until we see kind of how long it's going to take before we start moving to whatever the new normal is going to be here. But I think it's great that Magistrate Judge Litkovitz got that case settled. That I hesitate a little bit about whether that environment is as conducive to achieving resolution as an in-person setting.
And I will say that both parties chose to move forward with video settlement conferences as opposed to putting it off.
If that were the case, part of my typical theme that is emerging is if both parties wanted to pursue a video-based settlement conference, as with most other things that the parties are in agreement that they think it'll work well for them, I'm not going to push hard to say no on that.
Karen, are you comfortable that the confidentiality nature of the conference you had was maintained, that nothing leaked from one side to the other based upon the technology?
Yes, I do, because you could see the participants drop off when it was time for me to speak with one side or the other. The other participants completely dropped off, and you could physically see that. And I feel confident that it worked.
Okay.
Judge Barrett, you're big on settlement conferences, Judge Barrett, and I suspect it's part of the way you conduct them. Are you eager to do video settlement conferences?
I think I would tend to agree with Doug and Karen. If somebody really wanted a video conference, we've had some preliminary discussions on that. I am by far the least technological savvy of this group of 5 people that's on the horn right now. So I'm a little bit leery about screwing something up. But the lawyers that have had settlement conferences with me know that they're to submit ex parte papers ahead of time, and I always do follow-up ex parte calls with everybody. And I think if I sense that we were moving in the right direction and that getting people together by teleconference would work, I would probably be agreeable with that. I still have maintained the practice of doing the ex parte calls back and forth, and we've moved some cases to some extent using just that But I'm a big believer, and I think Karen was mentioning this a little bit earlier. I mean, sometimes the clients especially have to see you and feel like you're talking to them and that you're reasoning with them. And I think by video conference, that might be a little more difficult. Although, frankly, I'm impressed by the technology we're using right now. And I was impressed when we did our, discussion last week of setting this up. This seems to work pretty well. And if a client was comfortable with that and I thought I could reach them, that would be fine. The usual deal, like you always get the call from the insurance adjuster. Do I have to be there? And the answer is yes, because it's harder to say no in person than on a telephone or a video conference. So I like having people that I can reach out and touch and violate social distancing if I have to. So, I haven't tried it yet. I'm open to it. If all the lawyers are comfortable with it, I'm sure I'll give it a shot. We haven't gotten that far yet with anything. We're just doing it the old fashioned way so far. But, a lot of it, I think, depends on what Doug said. If this thing ends up rolling past May, through the summer, I think it's going to be probably a necessity in some cases. If it's just going to be 30 or 45 days, we can talk about it. So, I'm open to it. I'm frankly leery because of my lack of skills.
Fair enough. Just in the spirit of full disclosure, I'm not especially interested in doing it. My experience has been that physical presence and my general good humor are very important to settling it. And I think that would not be as well displayed video-wise. Judge Bowman, did you have a comment?
I did. I just want to add that it's my understanding that GoToMeeting does allow breakout rooms if everyone is using Google Chrome. I haven't tried it myself yet, but I'm hoping that we do have that ability. The other thing that I think is important for civil litigants to know is that our resources are limited. The GoToMeeting that the court has licenses for are for criminal proceedings. So the magistrate judges share one and the district judges share one. So all criminal proceedings take precedent over any civil matters. So we will have scheduling issues with using GoToMeeting for civil cases as well.
Stephanie, can I ask Karen a question?
Yes.
Karen, because of the technology involved, did you think it added substantial time to the length of the settlement conference, or there was no appreciable difference?
It did add some time to it, yes.
Okay.
That reinforces my own conclusion. Be that as it may. One more question, then we'll go to audience questions, Judge Bowman, if you're willing.
I would just say, Tim, just an observation that your demeanor is coming across fine on the camera.
Moving right along, what do you make of oral argument? I guess we're done with that, huh? Judge Cole, you're a big oral argument. You're a supporter of oral argument.
I am.
What about oral argument?
I have not done oral argument by video conference. If the parties wanted to, again, I would try it. I guess the Supreme Court is live streaming arguments in May, so there would be some precedent supporting that. I think that's one use of video conferencing where it may be almost as effective as doing it in a courtroom. It seems to me like that oral argument setting is one, because there's usually just the judge and one litigant at a time kind of going back and forth. I can see how this technology would work pretty well for that. And so I would be I'd be more open to that for an oral argument or I'd have more hope for a successful oral argument than for a successful settlement conference, I think, given this technology platform.
Tim, in the past, because lawyers are sometimes out of town and things, I've had oral arguments telephonically where they're just put on the speakerphone in the courtroom, and we go through it, and that's worked okay. It's not great. It's not like a live argument, or not like an in-person argument, but it has worked. So, I'm open to anything that people think will move cases.
Well, if I were ever to grant oral argument, I would not have a problem doing it on the phone or by video. What do the magistrate judges think?
I would prefer them by video over phone, but I'm happy to try them either way if the parties would be agreeable.
And I'm the same.
Fair enough. So life goes on. Work continues to be done. Judge Bowman, did you have a question from a participant who's part of this webinar?
We had two, and they both were relating to the settlement conferences. So I think we addressed them, although one question was, what could they as lawyers do to assist? And the only thing that I could think of was if we were using GoToMeeting through the court, that they utilize Google Chrome so that we could use the breakout sessions. Does anyone else have any other thoughts for what the parties could do to assist?
Yeah, and Judge Bowman, I think I may have, if you got that info from me, it may have been somewhat misleading. I think that's GoToTraining, I found out. It's not GoToMeeting, and our license does not extend to GoToTraining, although there is some thought about that. But GoToTraining adds the breakout feature that is missing from GoToMeeting. So I'm not sure that that would work.
Thank you for that clarification.
Yeah, no, further investigation proved less fruitful. So.
All right, very well. And I don't know if, I know some law firms have those programs in their firm. I would be hesitant to utilize a firm's license just because I think then the firm would be the host, and I would feel more comfortable having the judge have the host, I don't know what you call it, abilities to mute people and transfer people and the like. So I think we may have to then just utilize it when we can, the way Judge Litkovitz did with people dropping off the call and calling back in.
Tim, can I chip in there just for a second on a point? And we bring this up when we do our admission conference every year. We have our judges panel, but especially in a situation like this where the communication is perhaps a little more burdensome than it would be in face-to-face. If it's one of those situations where you go in and you meet with the plaintiff, you meet with their counsel, and you ask where they want to start, and they ask for a few minutes to talk, I think that would be a much more aggravating situation than in this context than it would be in an in-person. I mean, it's always frustrating when the client and the lawyer don't know where they want to start, and you always, you spend a half hour of the negotiation session getting over that first hurdle. And so I think if counsel want to do that, and that goes for defense counsel too. I mean, you guys know what your first response is going to be no matter where the plaintiff is, but the plaintiff ought to know where they want to start. And I think defense counsel should know where they want to start, so we don't spend that first hour doing the gymnastics that we all put up with on a routine basis.
So if we're going to do a settlement conference by video, people need to be prepared to hit the ground running and not stop the video while they confer. Is that the thrust of it, Judge Barrett?
Yeah, when they come in live, it's just something, that you go through fine, you talk to everybody, and it's just the thing, but everybody's together, so you add a half hour to the conversation. But if people have to disconnect, they have to conference, I mean, you ought to at least know where you're going to start on both sides to kind of get the ball rolling.
Fair enough. Fair enough. In response to the question, what can the parties do? Well, they can settle the case without the intervention of the court. So moving right along.
That was helpful.
I'm sorry. Thank you, Judge Barrett. Is there something wrong with your hair?
It's your screen.
It must be. It looks translucent or something. Be that as it may, how does one file a pleading under seal?
Well, I think the provided that they have the electronic ability, so if it's lawyers that have previously been granted the ability to file seal, they can file under seal electronically. If they do not have those rights, my understanding is that they can drop the sealing document in the drop box. So there's drop boxes located at each seat of court. My understanding is they're in between the exterior and the interior doors, and they are checked every hour. And the boxes are locked, so when something is put in, it cannot be removed by anybody else except the clerk's office. So my understanding is that lawyers and pro se litigants are supposed to be putting their filings either under seal or the pro se filings in the drop box.
And anybody else got a sense on how you deal with sealed stuff when we're in the circumstances such as we are? Is that it? You drop it in the Dropbox and we check it every hour and proceed in that way? Is that your understanding, Judge Litkovitz?
Yes.
Do you want to talk about that, or you're going to just say
No.
yes?
I think Judge Bowman has covered it all.
Fair enough. We should have spoken of that earlier. As Judge Bowman indicates, there are drop boxes in both entrances between the front door and the walk-through door. It's locked. You put something in, nobody can get it out. A case administrator checks it every hour and will act accordingly. Judge Bowman points out that one can get electronic access to file under seal. And moreover, at least as to my chambers, if you need to get something filed by seal and you're having trouble, call my chambers and we'll get you to email it to us, and we'll file it under seal for you. But life goes on. We can do this. We're doing well. So if you got a new FCA case that's supposed to be under seal, you drop it in the Dropbox. Or if you have sealed access, you can do it yourself. Or in my chambers, you can send it to us and we'll do that. My chambers probably will no longer be speaking to me, having suggested that. Is there anything more on the issue of sealed filings from the panelists? Fair enough. Any other questions from the group, Judge Bowman?
I don't. No, we have no new questions from the participants.
All right. Well, we are tending toward the end. So if you have any questions, particularly for Judge Barrett, please present them now as we move along. But sort of a closing type question, not necessarily the close, but how would you define or describe the efficiency at the remote work environment? How are you and your chambers doing on being efficient remotely? Judge Cole, would you kick it off?
Sure. I think the environment presents some challenges to productivity. I think that part of keeping cases moving forward is the ability to kind of bop into your clerk's office and kind of bounce some ideas back and forth. And you can do that telephonically, but I don't think it's as necessarily as effective as if you're both sitting there across the desk from one another, across the table from one another, looking at the same copy of the brief and looking at handwritten comments on, or handwritten copies on a draft, comments on a draft opinion or something. So, I think we're all adapting, but I think it's probably not as efficient as it was when we were in chambers. I certainly welcome the prospect of being back in chambers on a routine basis and, resuming that type of work rather than trying to do it all remotely. But that being said, the fact that we're having continuances in some of the criminal matters and some of the parties are seeking extensions in the civil matters is kind of creating a breathing space that allows us to get to some of the motions that are pending on the docket. So in that sense, it's not been a non-productive time. I just think it's probably not quite as productive as if we were in person. That's just my take.
Are you eager to get back to it and see lawyers and see your staff?
Yeah, well, as you pointed out, Judge Black, I very much enjoy oral argument, having attorneys in the courtroom, and I'm very much looking forward to when we can resume our sort of more normal courtroom activities. And just looking forward to having the chambers be not a virtual chambers, but an actual physical chambers again, and having all the clerks and the courtroom staff, and of course the opportunity to interface with all my colleagues on a daily basis. Missing that as well.
Fair enough. Judge Barrett, how's productivity remotely in your chambers? Do you want me to answer that for you, or do you wish to speak
Well,
to?
no, I mean, I know in your case, Tim, that you've been a fan of physical distancing for about 30 years, so this is all right up your alley. But there was a question that Katie sent out, I think this week, but there was a question that was asked about, is it possible for interested law students to observe court proceedings or hearings remotely? And that prompts two issues that we've talked a little bit about it, but as everybody on this call probably knows, we have a pretty vigorous summer extern program. And frankly, I have no idea where an extended order will put us in that regard during the course of the summer. So I think we're going to be a little bit in limbo till we really understand. We have in our shop, Kathleen's been coming in every day, and Barb's been coming in every day, and so have I. But everybody else is working remotely, so we're trying to maintain the physical distance in the chambers, and everyone else is working remotely. So it's been a little odd. So we're working through that, and I'm not quite sure, how the extern program will interface with the limitations we have. We've talked a little bit about it, but I think we're kind of waiting to see where we are around the 1st of May to kind of figure out what's going on. I do have a feeling that it's going to totally mess with our summer mock trial program. So I got a feeling that might not happen this summer. But it also prompted another thing which I've considered, and I haven't really had to deal with it yet. And maybe we can talk about this, but oral argument in a civil case where the litigants are corporations or employment cases or something like that, that's one thing, but oral argument in a case that has public interest might be another thing altogether. And the question was, how do law students observe? And I guess my question is, if you have a public interest oral argument and a news outlet or interested people want to hear the argument, how the heck do we deal with that? Because courtroom proceedings are not to be recorded. They're not to be, copied or all of those things. I haven't had to come face to face with that yet, but I have had one discussion with that in a pending case, and really not sure where we'll end up on that if necessary. I don't know if anybody has any thoughts.
Yeah,
Judge Litkovitz?
I had that come up. I had a criminal hearing where the parents of the defendant wanted to appear, so to speak. So they appeared through telephone, through the audio portion. And my understanding from our IT department and some of the limitations we have with the video with GoToMeeting, the main participants, the lawyers, the judge, pretrial services, probation, appear by video, but then the public, the media, and family can appear by telephone. And at the beginning of the proceeding, I admonished everyone that there's still a prohibition on recording any court proceedings, and that's pursuant to standing order. And I asked everyone who was appearing by telephone to mute themselves so we wouldn't get the feedback during the video proceeding. And it worked well because I actually had to engage the parents during the hearing, and I think it went very well, and it was very helpful to have them present. So there is that capability. In my chambers, we will start doing orders for our proceedings that will have a phone number for the media, the public, family to call in for purposes of the hearing. And my sense is that more courtrooms will be doing that.
And I'll add that, sorry, Judge Black, go ahead.
No, go ahead, Judge.
I'm just going to say, Karen, you brought up an interesting point. We've had a couple situations where just boilerplate routine conference calls, but if there's multiple lawyers on the phone, more than one or two, I would suggest that if you're not talking, you mute your phone, because oftentimes that background noise throws everybody else off that's on the phone call, and it gets to be a little distracting at different times. So that's an interesting point you brought up, because that does happen. When you have 8 or 9 lawyers on a phone, usually there's a lot more background noise than necessary. And if you're on a conference call and one group has 5 lawyers in the same room and they're on a speakerphone, that also gets kind of distracting sometimes, just because of the way the audio works. So it works best if you're on one line, and if you mute yourself when you're not actually talking. So thanks for jogging that, Karen.
Judge Bowman?
The CARES Act, as well as several general orders that Chief Judge Marbley has signed, also addresses how the media can listen and participate in criminal or important hearings. But I wanted to point out, as Judge Litkovitz indicated, General Order 20-07A specifically reminds everyone that the federal rules prohibit recording of proceedings and that the CARES Act does not include the recording. So that order does provide that sanctions will be issued if in fact the court learns that any proceedings are recorded or streamed or broadcast more than their intended purpose.
The court has put on a number of general orders relating to the COVID crisis, and those can be found at the court website, www.ohsd.uscourts.gov. I think you've gotten the gist of them, but if you want to look at them, they're all on the website on page 1. We have gone around the table. Are there any other questions from the audience, Judge Bowman?
There is. We received a question asking how we are handling local rule 65.1 conferences on newly filed civil injunction cases.
And I'll jump on that one. The local rule requires as soon as a pleading is filed seeking immediate injunctive relief, the court is to gather the parties at its earliest convenience for an initial conference where you discuss the motion for TRO and see if it can be a briefing schedule can be established or act on it. But it's same as always. We'll just do it by phone, do it by video, and the court will communicate with you. Anybody else have a sense on how they're going to deal with requests for immediate injunctive relief other than that?
No, I agree with you, Tim. That's standard operating procedure. If you're asking for a TRO, call, set up a time, and tell us what efforts you've made to see if the other side's represented. If they are, who is it, so we can get them.
Fair enough. Anybody else want to weigh in on TROs before we wrap? All right. Well, we've had a great discussion, and it's 12:43. We talked about going to 12:45, maybe even 1. But I think we've reached the point where this has been eye-opening for me. It's also really helpful for me to hear my colleagues talking about this. And in response to the question I asked Judge Cole, you want to get back to it? I agree. I miss my staff. I miss lawyers. And we're going to get through this. It's a finite period of time. I'm tempted to ask each of you when you think we'll be able to go back to work, but I think that probably would be inappropriate. I think we've reached the moment where I wonder if the esteemed president of the Cincinnati Bar Association is able to join us and perhaps speak on behalf of the Bar Association. The court is delighted that the Bar Association picked up the ball and set this webinar. So, Joseph Hyde, president of the CBA, do you wish to be heard by video and orally?
Yeah, wow. I think I'm unmuted. Hopefully everybody can hear me.
Yes.
No, credit where credit is due. The idea for this program came from the bench, from Judge Black and the other judges. So we, the practicing bar, thank you for wanting to have this dialogue. It is a strange time that we're in. And as civil litigants, most of us trying to figure out how to deal with every court that we need to deal with, it has been difficult. And to have this program where all of you talk about how flexible and amenable you are is really helpful to us, but also to hear from you, as Judge Black said, that you're open for business, that things are going forward, because we have clients who have needs, who need to, sometimes they can't work it out between each other, Judge Black, and we need the help of the court. And so thank you for all that you're doing to try to, not just to try to, but to actually keep the wheels of justice turning on behalf of our clients, on behalf of the matters that we're trying to litigate. But we all recognize that not only now, but when things do open back up, whatever that looks like, we're going to need to continue to be flexible amenable, civil with each other, understanding of things. And that's frankly where I think the bar of this community shines. And it's one of the hallmarks of practicing law here, is that we do treat each other with civility and understanding. And that'll be even more important when things open back up and everybody wants to be heard right away before all of you for the things that have been postponed. So thank you. I look forward to that time too, that we can all see each other face to face again, but it will be a challenging time as well. So I wanted to say that. The second thing is Judge Black mentioned the orders that have been issued by this court. We, the CBA, have collected all the orders that have been issued by our local courts, Ohio, Kentucky, the district court in Kentucky, the district court here, have collected them all for you on our CBA website. And we send out a weekly email so you can get all those links if you want to know what's going on. And if you have anything else that we, the CBA, can do for the 70-some folks who are on this webinar, please let Lisa McPherson or myself know. We want to continue to serve you as we get through this time. So thank you. That's about all I have, Judge.
That's a magnificent statement, and your motion is granted.
I didn't know I made one, but thank you.
Indeed. It's been a high honor and great privilege. This has been a good thing. I would propose that we adjourn. Thank you all for participating.
Thank you.
Thanks, everybody.
Thank you.
Thanks, guys.
Thanks. Bye-bye.
Bye.